అందరికీ శుభోదయం. గుడ్ మార్నింగ్ టు ఆల్ ఆఫ్ యూ. వెల్కమ్ టు లీగల్ మ్యాటర్స్ బై సాయిబాబు సుంకర్. Recently, of course, that is on 1st September 2025, Honorable Supreme Court of India, 2 judges bench gave a stunning judgment for which the state of Tamilnadu has come up for review of the same matter. This is relating to TET, Teachers Eligibility Test. Honorable Supreme Court of India, in the case of Anjuman Ishaat A. Taleem Trust, Anjuman Ishaat A. Taleem Trust versus the State of Maharashtra and others. Of course, connected cases are so many. Right, on 1st September 2025, held that the teachers already existing, already working, even in minority institutions also, should qualify the teachers eligibility test, TET. Otherwise, they have to go home. This sent shock waves in so many states. And why Tamil Nadu state has gone for review is there are 4,49,850 teachers. Teachers, I am telling about lower classes. 4,49,850. Out of whom 3,90,548 they are not qualified in the TET. So the minority education institutions, so many institutions, they have been aided, unaided. These people are taking the teachers. Of course, they have been continuously teaching the students for the past so many years without any complaint. That's going on. But the eligibility criteria, Supreme Court has fixed, and now it has become an irony for all the states and all the teachers. In this case, 2 judges bench, Justice Deepankar Datta and R. Mahadevan, they held that even in minority institutions, the teachers should pass the so-called Teachers Eligibility Test, that means the TET. Why? They have discussed Article 21A. Article 21A is the most important thing here. You have to discuss what is Article 21A. That is a fundamental right to free and compulsory education for the children between the age of 6 and 14 years. 16 to 40 years, they should be given the so-called compulsory education, free and compulsory. That is what is Article 21A telling. Therefore, the Act which came in the year, I think, 2009, Right to Education Act, we call it as RTE Act, Right to Education Act. Right. Then, if that is the case, now the Supreme Court judgment, judgment చూద్దాం. So many trusts they have found, they have filed cases. In that, actually, you have to know another case also. There is one case called as Pramati. That is Pramati versus, okay, I will tell you later. Failure teachers, it will come here. Minority institutions law. There is a judgment called as Pramati judgment. Pramati Educational Cultural Trust versus Union of India 2014, where Honorable Supreme Court of India, 2 judges or 3 judges, they said minority institutions are exempted from this TET test for the teachers. Because they are kept in a separate stage. Minority institutions, so right to freedom of religion, right to maintain some colleges, 26, 27, 28 law articles మనం చూసుకుంటాం. అది కూడా కాదు. Now you are clear that Supreme Court said that even in minority education institutions, the teachers should pass TET. మరి ఇప్పుడు నాలాంటి వాళ్ళు ఉంటారు, రిటైర్మెంట్ ఏజ్లో ఉన్నారు అనుకోండి, నేను ఆల్రెడీ రిటైర్ అయ్యాను, రిటైర్ అయిన వాళ్ళు కాదు, ఇఫ్ ఐ గాట్ 5 years of service, nothing will happen. Okay, you can do that. ఇంకప్పుడు TET రాయటం ఏమి కుదరదు, you can happily retire. But if you want to get promotion, you should qualify for the test. ఇది ఇంకా 5 ఏళ్ళ సర్వీసులు రిటైర్ అయ్యే వాళ్ళకి, కానీ ఇంకా ఎక్కువ సర్వీస్ ఉన్న వాళ్ళకి డెఫినెట్లీ దే హ్యావ్ టు కంప్లీట్, దే హ్యావ్ టు క్వాలిఫై ద టీఈటీ విత్ ఇన్ 2 years ఆఫ్ ద డేట్ ఆఫ్ జడ్జ్మెంట్. ఇది కొంపలు మురిగినాయి. ప్రతి వాళ్ళు టెట్ పాస్ అవ్వాలి. ఎందుకని? బికాస్ ఎడ్యుకేషన్ పాలసీ, నేషనల్ ఎడ్యుకేషన్ పాలసీ కూడా అదే ఉంది. సో కాబట్టి దెన్ what about the teachers who were recruited before the so-called judgment come into existence? మరి రాకపోతే ఏంటి పరిస్థితి ఏమిటి? 2022 నుంచే కదా వచ్చింది, దానికన్నా పరిస్థితి ఏమిటి అన్నప్పుడు నో డౌట్ సుప్రీంకోర్టు చేయండి ఎక్స్ప్రెస్డ్. సో సుప్రీంకోర్టు ఎక్స్ప్రెస్డ్ dislodging teacher, removing a teacher is a bit harsh as they taught students so far without any serious complaints, but still the law requires you have to be qualified. So please remember. And they said the Pramati Education Institution, that case, 2014 case, it has to be revisited. In eye of the Supreme Court, it is not correct. Of course, they have not clearly given any decision that is not correct, but they say they feel that it is not corrected. It has to be reconsidered. Right? SC expressed doubt about the correctness of Pramati judgment. So it needs a reconsideration by a larger bench. So children of minority institutions, they are also having the right under Article 21A. So therefore, you cannot give a blanket exclusion for all the teachers. Of course, basing on this, agreed by this, the government of Tamilnadu and more other states, they went for review. They say that Article 23 will apply. That means Section 23 of the RT Act, which says that the teacher should be qualified. It will apply, that is called prospectively in future. Suppose if you say that in future if any teacher is to be recruited, he has to be completed, he has to qualify for the TET అంటే పోయేది. అది అనకుండా పాత వాళ్ళు కూడా కావాలి అని చెప్పి సుప్రీంకోర్టు వారు చెప్పారు. ఇట్స్ ఎ బాయిలింగ్ ప్రాబ్లం. మరి అది ఏమవుతుందో చూడాలి. సుప్రీంకోర్టుకి రివ్యూకి వెళ్ళారు. ఆ రివ్యూలో ఏం చూస్తాం, ఇంపార్టెంట్ డెసిషన్ వస్తే మళ్ళీ చెప్తాను. ఓకే, ఫర్ ద ప్రజెంట్ ఐఎమ్ స్టాపింగ్ హియర్. థ్యాంక్ యూ వెరీ మచ్.